A very good morning and welcome to the fourth meeting of the Criminal Justice Committee in 2025. We've got no apologies this morning, and our first item of business is to continue our Stage 1 scrutiny of the Criminal Justice Modernisation and Abusive Domestic Behaviours Review Scotland Bill. So I'm very pleased this morning. We've got a good panel of witnesses. So can I welcome Laura Buchan, Policy and Engagement, Crown Office and Procurator Fiscal Service, and Emma Forbes, National Lead for Domestic Abuse at the Crown Office and Procurator Fiscal Service. Mr Malcolm Graham, Chief Executive at the Scottish Courts and Tribunal Service, and we have Superintendent Richard Thomas and Detective Superintendent Adam Brown of Police Scotland. So a warm welcome to you all. Thank you very much for taking time to attend today's meeting and for your submissions. They've been very helpful. So I refer members to papers 1 and 2, and I intend to allow around about 75 minutes for this session. So I'll start with an opening question just to get the session underway. A pretty general, broad question that will focus on part 1 of the bill, and can I maybe propose that I'll start on my left and I'll maybe bring in Laura Buchan and then Malcolm and then Superintendent Richard Thomas. So obviously part 1 of the bill makes a range of changes in relation to procedures in criminal courts. So in order for the committee to get a further sort of sense of your overall views of the proposals, I'd just like to ask you if you could briefly outline any particular provisions in part 1 where you have any issues or areas of concern. So last week we started our evidence sessions, and I think one of the issues that came up was around resourcing, but also some of the practical implications for the provisions within part 1. So I'll maybe come to Laura Buchan to start off.
Thank you, Convener. I think generally in terms of the submissions that the Crown have before the committee in relation to part 1 of the bill, the Crown are broadly supportive of the provisions there. We have seen the success of the temporary provisions in making efficiencies across the system. We've seen the flexibility that has afforded the system as a whole to deal with criminal business, and just the efficiencies and innovation that underpin the provisions that have been in place, so seeking the extension of those. We need to work together across the system in relation to modernise the system and future-proof it for future years in a framework that supports that modernisation. I think, as we've heard from some of the evidence before the committee before, there will inevitably be practical implications. I don't think in terms from the COPFS submissions that the practical implications are impactful to that extent. A lot of the changes and modernisations in process are now already in place, and actually it would cost more to unpick those if the provisions weren't extended. But we would work together with our colleagues across the criminal justice framework to support those processes that might be required to support any further work. I mean, we're at quite a significant and important change in the way that we're looking forward, where we'll have the rollout of body-worn video in the course of this year, and that will be really significant for victims, witnesses and accused in relation to cases before the court. That will sit along with DESC, the digitalisation of evidence, which is touched upon in the bill. And will build on the summary case management pilot that's been rolled out across Scotland in relation to front-loading summary courts with early disclosure and getting early resorts, which we know has been successful. I think broadly, then, Convener, that we are content to proceed with these and work with our agencies.
Okay, thank you very much for that. I'll bring in Malcolm Graham.
Morning, Conveners, and thanks very much for the opportunity. I would broadly agree with what Laura has said. Maybe go a little bit further. Not only have many of the provisions that have come in on a temporary basis been useful, they've now become essential. And I think in terms of both efficiency and effectiveness, it's allowed a shift over the years that they've been in place towards more person-centred and trauma-informed approaches, We will continue to seek to improve that in terms of the joint working that lies behind many of the measures, things like electronic signatures, many of the aspects of virtual attendance, how we've used that for remote balloting. It would be a real retrograde step if we weren't able to retain elements like that. In relation to some aspects of virtual attendance which have been piloted, for instance, around about custody hearings, I understand some of the practical, logistical and technical issues that have resulted in various pilots being paused or stopped. And the position going forward is that we're going to do a wholesale evaluation, take a different approach to all the lessons that have been learned before we move forward. And what will be essential in progress in that area will be working very, very deeply with all the court users, professional bodies, the legal profession and the justice agencies to make sure that when we take steps forward, it's going to work for everybody. But I actually believe a lot of these measures are not only underpinning efficiency in the future, they also underpin transparency and fairness and opportunities for access to justice that previously we didn't have. In relation to resources, I think there are some questions to ask. In the written submissions, broadly speaking, a lot of the costs are already captured or they're entwined in other measures that during the course of the response to COVID, etc., we had to put in place more broadly and very quickly. There will be a lot of indirect costs, and it's safe to say that some of the changes that the legislation would facilitate potentially in the future that we're not doing at the moment are likely to have significant implications for built estate and ICT. But I don't think that's a reason not to ensure that the legislation's there so that we can move forward to make that case.
Thank you very much. And I'll bring in Superintendent Richard Thomas.
Good morning. Morning, Convener. Thank you. Yeah, absolutely agree with my colleagues' positions there in regard to the proposals and how welcome they are in terms of providing swifter access to justice and better outcomes and bringing us up to date really with the technology that's available and that we in some cases have in place, particularly around virtual attendance at High Court and so on, that are already in train. So I think from the outset, our position, Police Scotland's position, is that we're very welcoming and supportive of the provisions in the bill. I would caveat that by saying that the pragmatic and practical implementation of the provisions is where we have the most concerns because of the realities and the operational, logistical, and in some cases administrative obstacles that would need to be overcome in order to make these provisions workable in reality. And we, even as recently as last Friday with Storm Eowyn, we saw evidence of the efforts to stand up virtual courts really not being able to be facilitated for a number of reasons, which gives us some concern about, I suppose, that the bill, while we agree with the content and the sentiment behind it and welcome it, as I've said, there are real questions about the feasibility of it being implementable on day one, particularly around the virtual courts, where the suggestion in the bill is that the court can direct or may well expect a virtual attendance to be available at every opportunity, which is simply not deliverable under the current operating model. So while we welcome the proposals, we do recognise that there is considerable work to be done between now and December in order to allow us to put resources, facilities, IT, infrastructure, and in and amongst other ongoing transformation work that is also not funded. This is one amongst several pieces of significant transformation work ongoing in Police Scotland, for which we would really need to be supported and funded in order to deliver.
Okay, thank you very much. That's really helpful. So, I mean, I think a sort of clear theme around the practicalities and the cost implications around that. Just one follow-up question, and I welcome anyone coming back in on this. So last week we took evidence from, amongst others, the Law Society, and Stuart Munro made reference to a piece of work that's going on, supported by a working group convened by Sheriff Principal Aisha Anwar, and that's specifically looking at the development of a virtual custody process that would meet the concerns that had been sort of identified, if you like, in a pilot, a pilot that's been running, looking at virtual custody process. I'm just interested in if the working group, the work of the working group is something that you're sort of respectively involved in. I'll just come straight back to Richard Thomas then.
Well, Police Scotland are represented on the working group.
Yeah.
I'm not personally, but I believe that Mr Graham is.
Welcome, Graham.
Yeah, thanks, Convener. Yeah, I've got a key role in reinvigorating that working group. As I mentioned briefly in my opening comments, we're going to take a slightly different approach to the path that we were on. I think what had happened was an awful lot of work had been done on the basis of a variety of pilots that had operated in different places in different ways. But we maybe attempted to move too quickly towards the notion of a national solution. And when I came into this role a number of months ago, I wanted to make sure that we had an opportunity for a bit of a stock take in terms of what had been learnt from the different pilots, and also making sure that we were taking on board all the views from the different court users. And I've worked very closely with Stuart Munro and other colleagues. It's also linked to the work that we're trying to do to get a fully trauma-informed end-to-end court process up and running through the trauma-informed domestic abuse model in the North East, which I'm very keen to make progress on. And I want to bring the learning and the engagement for both those pieces of work, which Stuart Munro is also sitting on the group for, which I chair, together, and make sure that when we move forward, we do it in lockstep with each other, which I think we can achieve.
Super, thank you. And I take it you're also involved.
Like Richard, I know of them, I'm aware of the group, but I don't sit in the actual group, so I think probably Malcolm's given the most up-to-date information.
Perfect.
But again, we know of and are involved in various pilots and have been involved in pilots. And we know that there's one specifically in relation to trauma-informed process in GH&I that's been running. So, yeah, supportive of any model to progress it.
Great, thank you. Thank you for that. OK, I'm just going to bring in other members, and I'll kick off with Liam Kerr.
Thank you, Convener. Good morning, panel. Superintendent Thomas, I'd like to explore something you brought up earlier on. Section 2 of the bill allows the court to permit virtual attendance at court. Now, the Police Scotland submission suggests that that isn't always practically possible for the police to do this, and notes that the bill, or that the ability of the police to facilitate this, is not part of the court's consideration. You also, or Police Scotland also say that the current budget won't allow the police to increase without cannibalising from other areas. So do you know, Superintendent, how much extra will be required to make this feasible? And in any event, does this committee need to amend the bill in any way to facilitate this, such as by making Police Scotland's ability a factor in the court's consideration?
Yeah, so thank you for the question. It's probably a bit early to apply specific price tags to the implementation of the legislation, because at this stage there are still unknown questions about what Police Scotland's estate is going to look like in the future. We're undergoing a transformation review, particularly with regard to custody and the type and number of custody facilities that we have available. There are other factors at play as well, such as the GOAME contract, which is up for potentially re-tendering, and there may well be cost implications with that. But in terms of some preliminary cost estimates, and we have submitted a separate response to the financial memorandum as well, which I note is in the papers, but our response isn't, so that would explain why it isn't in there. But from a preliminary cost estimate, depending on the particular options we have around how many police custody units we have, what kind of shift allowances are required in terms of matching the court schedules and so on, the CJ PCSO additional recruitment to facilitate virtual courts would cost anything between 1.7 and 4.5 million pounds. Capital investments to improve virtual courtroom infrastructure to allow implementation of the Act would vary from 12 to 44,000 pounds, depending on how many rooms we needed to put in place across the estate. And that would speak to the virtual courts. There are other costs that might well be accrued as a result of the desk or the digitalisation of productions. So the current desk project, which I think is about £33 million, has pretty much been spent, if not overspent. So in terms of implementing the digitalisation of productions, there would be other costs that would arise as a result of changing processes and procedures to accommodate digitalisation of productions. And so there are other unknown costs at this time, but we would work closely with partners to ensure that any costs were captured across the CJ process, not just within Police Scotland. But that's maybe an indication of the kind of financial costs that might be incurred as a result of the enactment.
I'm very grateful. And did you have any thoughts on the amendment?
Yes, so that was the second part of the question. Probably if there was something in the bill that could allude to, because at the moment the way the bill is written is that it sort of implies an expectation that a virtual court would be available at the instruction of the court. But it might be as simple as adding something in to suggest that this would be contingent on the availability or feasibility of that being delivered. I was at St Leonard's this morning, and I was quite keen to see the upgrade that's taken place within the custody facility there. There's one virtual court facility within St Leonard's. On a Monday morning, they could have upwards of 20 persons waiting to go to court. And I asked the sergeant on duty if it would be possible to facilitate virtual courts for 20 or so people, and it was just simply out of the question. So clearly, in a court as large as Edinburgh Sheriff Court, the bottleneck is obvious that it would be in terms of the estate and the ability to facilitate that, and that would require a significant increase in investment in IT, facilities, staffing, and the like.
I understand. Thank you.
I think, Sharon Dowie, you might have something that you'd like to come in on just as a follow-up to that.
It's kind of in the same line of questioning. The bill basically says that it's a default position that you would still attend in person. But I'm just wondering if you could maybe outline the everyday straining officers who are currently requested to appear at court and the pressure this puts on the service. So what are the current pressures that the police have attending court?
Yeah, obviously, the physically being required to attend a court implies time, not just the court's time, but the officer's time. It means time away from frontline duties. There are kind of workarounds whereby officers are allowed to work, from a police station, although not deployable operationally. When they're on standby for court, there are cost implications or lost opportunity cost implications of being on standby for court, having to attend in person. So, as I said at the outset, anything that could streamline or reduce the impact on frontline policing by either deferring the attendance or having a virtual attendance or having evidence agreed in advance, such as in the summary case management pilot and so on, all of those would work towards an improvement of the conditions and allow police to deploy more officers to frontline duties than is currently possible in the model. So clearly we welcome that, but really just to flag up the pragmatic issues that we'd have to overcome in order to enable the Act to take effect.
Right, so I'm just looking at the practicality. So the virtual court appearances could ease strain on officers, but are you confident that virtual system would still be practical for officers in their everyday work? I'm just wondering how they would actually be operationally. So if it's actually going to be of any benefit, because you can't actually go out in frontline duties and be operational if your case suddenly gets called in at the court and then you have to be given your virtual evidence. So you wouldn't actually be able to be out doing frontline duties at the time.
Yeah, I mean, I think the demand for an officer to be available to give evidence is going to be the same whether they have to physically, attend a court or physically attend a virtual court is not dissimilar. But I think the efficiencies are realised across the criminal justice system in terms of probably for other agencies as much as for police officers. But yeah, I recognise that there's still a demand on police officers to give evidence, and that has to be done either from a virtual court or from a physical court. So yeah, I understand.
So,
Yes.
I think where we have seen the benefit in that point is specifically for police officers that are in the Grampian Highlands and Islands if they are cited to attend High Court cases in the Central Belt. So the use of virtual attendance in High Court trials in those circumstances, and I think Malcolm had provided the numbers of professional witnesses that had appeared virtual in his submissions. So albeit, I think Richard's position would be they would require to be a police station to be able to give evidence virtually. They would not have to then have the time to travel from a remote location to get to the Central Belt. So there's time saved there. And there are other duties that can be carried out. So again, it's not about, in terms of a lot of these provisions in the bill, it's not about all police officers giving evidence virtually. It's not about all professional witnesses giving evidence virtually. But the benefit in police witnesses and professional witnesses such as doctors and nurses being able to give evidence from another site and not having to take the time to travel to court, there are savings made and efficiencies made there as well.
Right, so again, this just might be my understanding of witnesses then. So I thought when you go to court, you go to a witness room so that you can't hear any other evidence that's been given out. So does that not mean that even if the police are given their evidence virtually, they still have to be in a separate room so that they can't actually hear anything that's going on in the court? No?
I think if I'm able to come in answering that and some of the other points, we're not actually talking about creating a virtual court where everybody would be in different places. What the provisions are seeking in this part of the discussion is the remote provision of evidence by certain witnesses, which effectively means that they are separate from the rest of the court proceedings and they can be at a place. I fully understand the issues about the requirement for the police to have facilities that have the connectivity and the technology to be able to connect into the court at the scale that's required, and at the moment that isn't in place. But those individuals can effectively go about whatever business they can within the building that they're in, which I think was the question you were asking about, could they be out doing full operational duties? Possibly not. But we did provide some examples where for some people that is a really, really significant saving. And my understanding of the intention behind the measures as they were brought in and as they're being used isn't for it to be restrictive or compelling on witnesses. It's meant to be enabling. So it's something that the police have asked for. It's something that other expert and medical witnesses have asked for and welcomed. And during the course of the last 6 months particularly, we've seen a really steep rise in the number of people who are making use of that provision. But it's not something where the court is compelling people to do it. It's something where it can be facilitated, where it's of mutual advantage. There are some benefits for the court and for the Scottish Court and Tribunal Service, but they're not on the same scale as they are for the bodies or individuals that are giving evidence as witnesses.
Okay, and just the last one was one of the issues about officers having to attend court that we hear about is that they're having to come in on their days off, sometimes having to cancel holidays or fly home for holidays. I take it this virtual appearance won't help that in any way? So
I think that's not directly related to the bill, but I think that, well, I know there are other pieces of work ongoing with colleagues at the Crown with regard to court scheduling to help reduce the amount of time and occasions that officers are required to attend when they're on annual leave or days off or night shift and so on. So that's a perennial issue. Probably slightly separate to this, because it's work that's ongoing, has been for a long time, to try and get that system better. And I'm hopeful that is something we would address in future, because clearly it's not in anybody's interest for officers to be attending court when they could otherwise be deployed or on annual leave.
okay, thank you.
Thanks.
I've got quite a bit of interest in this particular issue. I think, Pauline McNeill, do you want to come in on this? And then I'm going to come back to
virtual
Liam Kerr.
attendance. Yeah, thank you. Good morning. So, first of all, so you understand where I'm coming from in my line of questioning, I think we're all agreed that it can be helpful to the court system for virtual attendance, where everyone's content with that. What I'm trying to do is drill into the detail of the balance between the saving of time and the fairness to the processes, so that's what I'm really interested in. I wanted to begin by asking, I don't know, Laura Buchanan, it might be you, but you can tell me, and or maybe Malcolm Graham. So there's been quite a lot of concern raised by defence agents about tying up the importance of them being able to talk to their clients. I did attend a virtual custody session in Glasgow Sheriff Court about 18 months ago. I could see there was lots of issues. In fact, the Sheriff was literally had a break and said to me, this is what this is like, this is just impossible. Which speaks to the whole thing about the importance of the quality and everything else. And frankly, I couldn't even identify the accused on the screen from what I could see. So, okay, so we all want to be in a different place from there. So my first question really is, how are you going to ensure, because Simon Brown gave evidence last week that, given we all know as well about how stretched defence agents are, they can't be in more than two places really easily. So one's a virtual hearing and one's not. So I'd like, if you could address that, how are we going to make sure that defence agents can deal with virtual attendance of accused persons?
Well,
Well, I was actually, my first line was going to say, I think this is probably for Malcolm to answer, so I'll maybe ask him to go first in relation to the practical setup of virtual custodies.
Yeah, no, really welcome the question and understand the legitimate concerns about some of the pilots and how they've operated. That is the purpose of a pilot, is to test things and learn, recognising that they won't always work, but then make sure that you do move forward with something that recognises the feedback that you've got from people, which is why I've explained we're going to take a slightly different approach going forward. I think the points raised about defence agents having to be in more than one place at once are legitimate in certain circumstances. I understand if there's a defence agent who operates in one court, then effectively they manage cases by moving around the different courtrooms within that building. But there are also defence agents who operate across different courts, and they can't do that in person at the moment, but some form of virtual, for instance, custody hearings could facilitate that between Aberdeen and Inverness, or Dundee and Perth, wherever it might be, that you wouldn't have the opportunity to travel between facilities. I think, and this also goes for the trauma-informed domestic abuse model, I think the crux of this being successful is to make sure that we find a way to provide adequate facilities for defence agents to be able to do virtual hearings or remote consultations with their clients within the court building. And a lot of the pilots, when they were run, didn't have that because the court estate at the moment
and
really
have you now
doesn't
discussed that with
facilitate
defence agents as to whether they think that that will work?
They think that that's the right way to go,
Okay.
but of course I think, and understandably, they will wait and see as to what we can provide. We're already seeking to do it in the High Court in similar circumstances, where I'm in quite advanced discussions with the Faculty of Advocates about providing additional facilities in the High Court premises that are running at the moment, where advocates will be able to move between the court building and a facility which effectively they can book, but we can manage on their behalf to ensure that scheduling with court hearings and the availability of defence or agents or counsel can come together. And whilst we haven't completed that, I think the conversations are really, really positive. And we've had a similar set of conversations with the Bar Association in Aberdeen around about the trauma-informed domestic abuse model, and they are supportive of us progressing it on that basis.
And I think we would be supportive of all that in relation to, I mean, I was involved in one of the pilots, and in relation to the quality of the consultation, it was clear that the partners were working together for improvements. There is, of course, a benefit for accused. We at times deal with very vulnerable accused, and sometimes they can be transported for up to 3 hours to a court for a very brief procedural hearing. And so if there is better use of and better quality of the opportunity for them to have a consultation and appear virtually, that would limit the amount of travel required. There are hearings at which, and I think the default is, of course, that people will appear in attendance, and there are appearances at which absolutely people will require to be in person, but there are other hearings where there wouldn't require to be personal appearance.
Thank you. I now want to ask questions about the other power that the Lord Justice Clerk, Lord Justice General, can exercise in relation to others who can appear virtually. So, just so I've got this right, Malcolm, it's the case that in every individual court hearing, the Lord Justice General will decide. It's not a blanket power.
I think there is a provision for there to be a direction issued which will make a provision for certain types of witnesses to, as a matter of default, provide their evidence remotely.
So is that like public officials?
Yes.
Yeah.
And expert and medical witnesses. Yeah. And in effect, that direction is in place at the moment.
That makes sense. In relation to other witnesses for trials, what is the test then, do you think, that's going to be applied? Something I'm interested in. Because at the end of the day, what matters in criminal justice, I'm sure we all agree, for all the technology, is there must be fairness and justice. So I can't find anything that tells me what criteria would be applied for the Lord Justice General to make a decision in an individual trial. Is there going to be any guidance issued about that?
Yeah, I mean, the first thing I would say is I understand there's a requirement for any such direction to be made public. So, within that, the rationale would be contained, and that would support, transparency, fairness, access to justice. As I said earlier, I think it's probably a matter that's more properly directed at the judiciary than the court service. And I know that the senators have submitted in their written evidence in relation to the bill a number of options that could be explored in that regard, but I don't seek to speak on the behalf of the judiciary. I'm part of a separate body.
Fair enough. We'll go back to them then, if we're clear. Just lastly, I have to say I was quite concerned at some evidence I heard last week about... I can understand why people would want to give their evidence in the comfort of their own home and for them to feel, but there's got to be some limitations in this modernisation. Cannot be. I don't see how you can control the environment if you extend these allowance of virtual proceedings. So can you help me here with, as far as you're concerned, what are the requirements for a witness to give evidence virtually? Must it be given in a particular setting prescribed by you? And as Sharon Dowie says, there should be no one else in the room, and all the other things. And how do you... The only way I can see that you could really monitor that is if they were in designated places. But I'd like to hear from you as to what your view of that is. Thank you.
I mean, I'll just offer a view, to some extent, have the floor. I don't think that's been fully thought through in terms of the wider provisions. I think at the moment, the measures that would be put in place around about police officers within facilities and police stations, or on the basis of medical and other expert witnesses providing evidence from a professional setting, which has been the very positive experience to date, is a different thing than broadening it out more generally. There are, of course, a lot of circumstances for vulnerable witnesses that are absolutely critical in this, and the facilities that are used for remote provision are either provided by the court service in terms of evidence suites, or they're provided by normally one of the third sector victim support and advocacy organisations who are very well equipped and able to both support witnesses and provide a suitable environment for that evidence to be given, whether that's done on commission in advance or whether in the circumstances we're talking about here it's done through a live link. Some of these provisions, and it isn't a point I've raised before, but some of the provisions that we're putting in place here through the bill that I talked about as being essential to retain are also of intrinsic importance for the victims and witnesses and criminal justice bill in relation to how the Sexual Offences Court, as it's proposed in that legislation, would operate as well. And if we don't get some of these measures in place, then we won't have some of that underpinning legislation to take forward the other elements of the Sexual Offences Court in the future. And understand that's a separate conversation, but I think it's worth flagging up as well.
So if it's not fully thought through, what do you think needs to happen to make it robust then?
Well, I think the elements that are proposed in the bill are fully thought through. I just think the elements that you've asked about in your question in regards of all witnesses are not necessarily thought through in terms of what the practicalities of, for instance, as you rightly say, preserving the sanctity of the court, ensuring the integrity of the evidence. What would that mean if people chose to, give evidence from certain settings, etc.? I think that work's still to come.
Yeah.
Well, we do have witnesses giving evidence remotely, regularly, but not from their own home, as Malcolm indicated, from just places out with the court building, which is very much supportive of the work ongoing Victims Witness Justice Reform Bill around the trauma-informed approach, specifically in relation to victims of sexual offences. I think my own personal experience is I've only ever seen a civilian witness give evidence from their own home on one occasion, and that was when they had very significant health issues. And on that occasion, it wasn't that they were attending the court effectively set up in their home, so there was a bar officer there to ensure the process was followed. So that is not my understanding of what the bill is proposing. It's continuing the flexibility that we currently have.
It doesn't give us much indication of where. Let's take a murder trial. Let's just talk about a murder trial, where there's a lot at stake. So a witness giving evidence is crucial, then perhaps for the defence. So what are the conditions that you think the witness should give that evidence in? Should it be would it be a designated space? Would it just be any old place?
No, absolutely not. But I think that the point that you raised earlier in relation to the court has control over that. So there would be discussion within the court.
I'm asking you as a parliamentarian to persuade me that I should pass this particular provision. What can you tell me about the conditions? I wouldn't be happy not to know that both the Crown and the court system would have a specific place or designated set of circumstances. Otherwise, how can it possibly be fair? How can I be satisfied that it would be fair?
Sorry, my colleague was wanting to come in.
So, at the moment, Scottish Courts and Tribunal Service have their own remote evidence. So when people give evidence by commission, for example, that's from a remote site that's run by Scottish Courts and Tribunal Service. You heard last week from Kate Wallace, and Victim Support Scotland are in the middle of a process of expansion of their remote...
Sorry, can I stop you? I know all this. What I'm asking is there a requirement that, see the Lord Justice General using the powers in this bill, because it has to be granted, says, OK, you can give evidence in this trial remotely. Is it a requirement to these facilities? Is it a requirement? Do you see where I'm coming from? Could someone say, well, we're not going to use those facilities, we're going to lose another...
So that's a matter for the... That's definitely a matter for the court.
Like that and, yeah.
So, but we had... So...
Just come in this in the spirit of time. I know this is an issue that you're very keen to drill down on. Is there an opportunity to maybe follow up with with a written?
No, actually, I'd like an answer if that's all right. I need to be satisfied. Just so you, I've seen the facilities are really impressive. My question is, will you expect every witness which has been granted permission to give virtual evidence to give evidence in those? Do you see what I'm saying? Is that a yes?
Well, our expectation would be that it is ultimately a matter for the court, so that's why the Lord Justice General's permission, isn't it? But
Right.
from a prosecution perspective, our expectation would be that evidence would be given from one of those court
Right.
suites or from one of the
Right.
approved
Right.
places.
That's-
Now,
I'm happy.
we couldn't.
I'm happy. That's what I needed to
that's
hear.
Okay.
But we also want to support the victims and witnesses who come to give evidence in trials that we cite. And we also want them to feel safe. And that's about their physical safety, but also their emotional safety. And those suites and the capacity for remote evidence provides an opportunity for that, because all of the evidence we have is that Scottish courts witness muster areas are not a place that victims and witnesses currently feel safe. And it's not because there isn't security or CCTV. It's because they don't feel emotionally safe, because it's a very stressful environment for them. And there's a lot of evidence on that. And so that's one of the other reasons why we think that the remote possibility is helpful.
Okay, thank you very much. Thank you for that. I think you're going to pass, and I'm therefore bringing Ben McPherson.
Thank you, Convener. Two follow-up questions to some of the points that have been raised by colleagues. And good morning. Thanks for your time. Firstly, I think it's just important to note with regard to the points that Sharon Dow raised about police officer time, and this also applies to expert witness time. I think it's important for us collectively to keep in mind that there are also other initiatives ongoing to agree more evidence in advance between the Crown and the Defence to reduce that necessity for police officers and other witnesses to attend court. And I see nodding heads, so I just presume that's taken. But I just think for our wider consideration and for the record, it's important to acknowledge that.
Yeah, I think, as Richard indicated, there's a significant amount of work going on between Crown and Police Scotland in relation to minimising the amount of time that police officers require to come to attend court. That has been impacted by the level of court that are currently in the court business and the increase in the amount of police witnesses that are required to attend. So the summary case management programme really looks at front-loading disclosure so that evidence can be agreed really early on in the process. And that would necessitate not just police witnesses having to attend court, but actually the citation of police witnesses in the process at all, which means that we know from Police Scotland, and I'm sure Richard will come in, scheduling police time, off-duty, holiday duty and shifts is really complex when we're looking to schedule in court time too. So if we can actually have a system in place where there isn't citation required because police evidence is agreed at the outset, then that whole process comes away. And I know that in the summary case management cases, we've seen success in that, in early resolution in cases, but also in seeing the number of citations for police witnesses and other witnesses reduce.
Yeah, I concur with that. And the summary case management, as it was piloted, was very successful. It's now, undergoing a national rollout, and that, in relation to particularly domestic abuse cases, was as piloted. But I think there's applicability across the range of summary case and potentially beyond that. So that's all to do with agreeing evidence so that police officers don't have to attend court and give evidence with everything else that's been highlighted in terms of demands and lost opportunities elsewhere.
Okay, that's helpful, and I think it's just important to acknowledge the wider context and that work is ongoing as well. And of course, we've seen the success of the pilot, and there seems to be consensus across all witnesses this morning that the pilot has been positive. There's been good outcomes. There's good progress being made, and now we're considering, of course, this bill in front of us. Going back to some of the points that were emphasised by my colleague Liam Kerr in terms of the finance and some of the points that both Mr Graham and Superintendent Thomas raised in terms of the practicalities, as well as finance and resourcing, there's time. that we need to think about. And whether it's just now or as a follow-up, what I think would be helpful for us as a committee, and I asked this of witnesses last week, is do you think the commencement provisions in section 28 of the bill are appropriate? And if you don't, what for you would be a realistic commencement that could enable all parties involved to make sure that they have worked through the practicalities, created the infrastructure, appropriately organised the facilities so that this can happen in the right way?
I think that's the big question that's hanging over everyone. I think my colleague Adam will speak to part two, and which is probably at a much earlier stage in terms of what the implications are for practical applications, even than part one of the bill. Again, it's alluded to in our written response, but we do have concerns that we don't want to have another bill that's enacted but cannot be operationally supported until years later. And Domestic Abuse Protection Scotland Act's an example of that. Royal Assent in 2021 and has yet to be fully implemented. And Age of Criminal Responsibility again took 2 years to come into actual application after it was enacted. And we're trying really to avoid that. Sorry, to answer your question, is that how long it will take really depends very much on the thinking through some of the questions that have been raised through the working group, but also around securing the appropriate funding. And I think that is really at the heart of our main concern about this really well-intentioned
As well as thinking about funding, I guess my request to you is, can you help us think about time? And it doesn't necessarily need to be today, but as we move forward in this billing process, if there is a more definitive position that you can give in terms of what would be a reasonable time frame for commencement, I think that would be useful for the committee to know. Mr. Graham.
Thanks very much, and a really reasonable question. As Richard's pointed out, the challenges in implementation in different types of legislation maybe don't apply here, though. As I said earlier, firstly, the vast majority of the proposals in the bill are already being used in one way or another, or to some extent. I think the intention, policy intent behind the bill is for it to be enabling, as opposed to for it to be a compulsion in the vast majority of cases. And therefore, having those enabling provisions in place allows us to then progressively realise where the benefits are at the pace that we can seek agreement, secure funding, rebuild the estate, whatever it is, all the things that we've talked about already. So my view would be that the commencement arrangements are appropriate within that sort of context and framework. And I would go back to where I started, that some of the measures in here are absolutely essential for us to be able to not only continue with a more efficient justice system, absolutely agree, summary case management has been and will be transformative. They're also essential for us to be able to move forward into a more victim-centred and trauma-informed set of approaches and court processes that also links into other legislation, as I said earlier.
I would simply echo what Malcolm has indicated. I think the vast majority of these provisions are already in place. I suppose, for example, the electronic signatures, which are totally embedded in the work that we do, in the vast majority of work between organisations is done electronically. If the provisions are not extended on the 1st of December, then there would presumably be a period where the provisions were no longer in place. That would be the concern from our perspective, that there would be a lot of work in returning to the processes pre-COVID with some time to work back to where we currently are. So whilst I accept Richard's position that there will be work to do in relation to get the full benefit of the provisions as they are currently drafted, the vast majority are currently workable and working well.
Richard, does anything more you want to add?
I'll just reiterate, but absolutely agree with my colleagues, and I think that that to actually go back once the temporary provisions stop is not a reasonable position. That we want to continue to have the enabling opportunities around the bill. We, totally agree that this is the way forward, that, all of the digitisation and IT processes that should be used should continue to be used and available. It's simply, for us, it's simply a matter of actually having the wherewithal and the resources to support them. And the concern is really just about, although the bill is written in a way that it suggests it's an enabling piece of legislation, the implication is that it would be expected, that it would be a default position. And that's the bit that we're just slightly concerned about, because if that is the expectation on day one, as things stand at the moment, we would really struggle to deliver that. And we wouldn't want to disappoint anybody by being in that position.
Yeah, sounds more like you wouldn't be able to rather than you would struggle to. Yeah.
And I suppose if I could offer some reassurance, the bill's broadly drafted in the same terms as the remote provision of evidence is facilitated just now, and there is no experience or expectation of the court to compel police officers, experts, medical witnesses to provide their evidence remotely if they don't wish to. It's a facility that, if the court can be assured it can be properly done, that can now be enabled for the advantage in the main, as I've said earlier, of the witnesses giving evidence, as well as preserving the sanctity, transparency and fairness of the court process.
Thank you very much. All that was really helpful for our evidence taking. Thank you. Thank you, Convener.
Thank you. Still got a couple of members keen to come in on part 1 of the bill, and then we'll move on to part 2. So I'm going to bring in Katie Clark and then Fulton McGregor.
Thank you, Convener. And my questions are probably most directed to Laura Buchan or Emma Forbes, and really are focused on the right to a fair trial and ensuring that we prevent miscarriages of justice. Now, some of the early pilots required agreement from both sides, I believe, for virtual attendance. I don't believe that's what's being proposed here. We know that a lot of professional evidence is disputed. We also know that the courts have not always accepted police evidence. So, given that we really should have a system where, for example, early pleas are encouraged and that cases are fully prepared to enable that to happen, and also if witnesses are expected to go through a trial and there's a guilty outcome, that should be taken into account in sentencing, the inconvenience to witnesses and having to travel sometimes very considerable distances. Can you maybe outline whether you see advantages in, for example, police giving evidence in person to ensure that evidence is tested, and what kinds of scenarios where you think actually evidence should be given in person?
Absolutely. It's a kind of balance that a prosecutor you have to weigh up when you're looking at the evidence. And I think you quite properly know in terms of the provisions, and as we said earlier, it's not about there's an expectation that all police witnesses or all professional witnesses will be coming. And the same will apply to professional witnesses. So, for example, I suppose in cases where there are medical evidence for both the Crown and the defence, where there is a dispute over what that medical evidence says, those would be a circumstance where you may wish the professional witnesses to attend court and the defence may request that they attend court. So there's no... there will still be a process where we're looking at the evidence of witnesses where either party could say, that is a witness that I would want to attend court. And that is something that would be discussed before the court, and ultimately the sheriff or judge would determine if the parties couldn't agree. But there will regularly be discussions at the moment between Crown and Defence where, for police witnesses, if it's procedural evidence that's not disputed, one might argue it should already have been agreed. But that if there is evidence that's required to be taken that the defence do not have an issue with, then that evidence could be given virtually or remotely. But there will be police witnesses where the defence agent will say, I would like that, I do not agree with what the witness says, or my accused has a different version of events to the version of events put forward by the police, and they will request that witness to come.
And what test is it that you understand will be applied by the court where the defence objects?
The court will just listen to the position. The vast majority of these will not be ultimately, I think, before the court, because it will be an agreement between the defence and the Crown. It would only be if there was a position where the Crown were saying, for example, a police officer for some health reason required to be giving evidence from a police station, and we said they really want to be there, and the defence said we need them in court. That might be something we would air before the court to say these are the reasons we think, these are the how we can satisfy the court that the protection will be there in terms of it will be in a police station, and the defence will give their reasons as to why they would want them there.
So your understanding is that where the defence objects, then the normal situation would be that evidence would be given in person, that it wouldn't be the default that evidence would be given virtually?
I think the way the bill is set up is just to ensure that it doesn't continue to be just all witnesses must come to court all the time.
But we have to look at the face of the bill and the black letter of the law, don't we? And that's not clear in the legislation, is it?
Well, my understanding from, I suppose, my reading of the legislation is the defence still have the opportunity to say they want witness to come and for the court to determine that. So it's not that they're presented with these witnesses will definitely be given evidence in this way. They have the opportunity, as we would have the opportunity if we disagreed. If the defence wished their witnesses to be given remotely, we might then therefore say we would like to have the opportunity to address the court as to why we want these witnesses to come.
The test that the court would apply, whether it would presumably whether it's in the interest of justice.
Yes.
And there's no further test or criteria set out in the bill.
Not that I'm aware in terms of how the consideration would be.
Thank you.
Okay, sorry, apologies, I was distracted. Thank you very much. Fulton McGregor.
Thank you, and good morning to the panel. It's been a really good discussion on the virtual attendance aspects, and I think we've got quite a lot out of that. I wanted to move on to the fiscal fines provision in the bill, and my questions are probably for the three to my left, but of course to police representatives could feel free to come in. You'll know obviously that the bill proposes to make permanent the temporary provisions on higher fiscal fines, the maximum of 500 as opposed to 300. I'm just wondering if you can tell committee how these higher levels of fines are being used currently, and what would happen if the current temporary measures are not made permanent. Would there be any concern with that? Laura?
So I think the rationale for prosecutors having powers to use the direct measures such as fiscal fines is that it delivers a swift and proportionate response to the alleged offending. So the increase in the amount of fiscal fine that are laid out in the provisions is broadly in line with the inflation over the years in terms of the increase to allow deputies to offer that range of fiscal fine for that type of offending. In terms of the figures, I think there was a letter sent to the committee regularly in relation to the use of fiscal fines, but I do have some further updates specifically in relation to the higher amount of fiscal fine band, just to reassure the committee that this is not a power that the deputies have been using really regularly. The higher issue of fiscal fines is not used regularly. Since the implementation of the revised scale, 2% of individuals offered a fiscal fine and less than 0.5% of individuals that offered a combined offer have been issued with a fine amount between £300 and £500. So it's a very small proportion of those that are reported to us that are actually given that fiscal fine or combined offered amount. We would like to see that provision continue. What we can see from the data, and we look at the Justice of Peace Court disposal data, is about 4% of cases currently in the Justice of Peace Court are disposed of by way of a fine between £300 and £500. So if we can identify those cases at an earlier stage, issue that fiscal fine, then that just removes those cases from the court process with the same outcome ultimately. Again, to reassure the committee, the police report these cases to us. A prosecutor has a broad range of disposals open to them when they're considering a case, and they don't have to offer a fiscal fine when they consider the circumstances of the case. They can determine that those cases should go to court.
Yeah, okay, that's been helpful, and I think you've been quite clear in terms of your view on the temporary provisions being made permanent. In relation to fiscal fines more generally, though, we did, you probably have heard about the session last week, we did hear some concerns that there is times they can be used inappropriately. I think one of the examples that were given was that, when there's maybe the same individual has had multiple fines and not paid them. Is there anything that you would want to say on that about the appropriate use of fiscal fines? And I suppose just to combine my questions together in the interest of time, I wonder if you could also comment what information victims are given when a case has been dealt with by a fiscal fine.
I heard the evidence last week. We would need, I suppose, more examples about where there is a feeling that fiscal fines have been used inappropriately. There is a robust process in relation to the consideration of cases. All our cases are reported, the vast majority of which are dealt with a national initial case processing team. So there are specialist case prosecutors that deal with marking cases on a daily basis. We've got really guidance around when the type of cases where fiscal fines should be considered. A part of that will be consideration of previous convictions and whether people have been previously offered fiscal fines. What I will say, and I don't know if any of you saw, but the end of last year, the Lord Advocate gave a statement to the Parliament about the pressure on the prison population, and part of that statement is around deputies and prosecutors thinking about what alternatives to prosecution could be offered to offenders. And what we know and we hear from our criminal justice and community justice partners is just because somebody has failed on a number of occasions to take the offer of diversion or intervention or of assistance doesn't mean that another time they're offered it, they might take that intervention. So we have to take all that into consideration. Now, if somebody doesn't pay a fiscal fine, then we can prosecute that person. So that's not the end of the matter, but there is an opportunity there for them to accept responsibility, to pay a fine, and that negates the requirement for them to come to court. It saves time in relation for victims having to attend court to give evidence, and it's a far swifter and proportionate response than having to cite people for what can be quite a lengthy court process in what would ordinarily be a justice of peace court.
And in relation to the question about victims?
It would be dependent in terms of what type of offence had been reported as to whether they would be updated as to the outcome of that in relation to it being a fiscal fine that had been offered, or if they would contact, we would inform that a fiscal fine had been offered.
Okay, thanks.
I've got two very final requests for brief questions and hopefully succinct responses. So I'll bring in Liam Kerr and then Pauline McNeill.
Thank you, Convener. Malcolm Graham, just on a matter that Ben McPherson raised, the bill doesn't look to address the temporary provisions extending some time limits in solemn cases, which are due to expire in November. Is the system going to be on track to deal with the pre-COVID time limits by November?
No, is the short answer to that, in terms of being brief in my answer. And I think when I was before the committee at the tail end of last year, I expressed great concern about the level of business likely to come particularly into the High Court and the projections from the Crown set against the capacity that the system, of which SCTS is just one part, will have to deal with that. There is a substantive volume of cases which will need to be dealt with, and the issue of the time bar is one which I understand is under active consideration, and Laura might be better placed to answer on that. But from an SCTS perspective, in terms of court scheduling, we've made great progress in terms of summary cases. We've made very good progress in terms of reducing the overall volumes and journey times of solemn cases in the Sheriff Court. But at the moment, with the volume of cases coming into the High Court, set against the capacity to deal with it, that's really running at what is a sustainable level at the moment. We're predicting that the number of indictments coming into the High Court is going to increase, and the likelihood is that the journey time of those cases will increase and the number of active cases in the system will increase significantly during the year.
I'll bring in Laura then to comment, but and perhaps in doing so, but Malcolm, you might want to come back. What's to be done in that case?
So, thank you for raising it. It's something that we are in discussions with our colleagues in Scottish Government about in relation to solemn cases. As Malcolm indicates, there's been significant process in relation to summary cases. There are still an amount of significant solemn cases, which is part to do with COVID, but also to do with an increase in significant serious offences, including serious sexual offences, that has continued as a pattern over the past 5 years. There has been much planning. There has been a significant amount of work with other criminal justice partners across to reduce the caseload. We are not suggesting that from the 1st of December, the cases that call when those provisions expire should not revert to the time bars that were in place pre-COVID. We are talking about the cases that are in the system now, the cases that are calling today, and we would like clarity about what time bars will be in place for those, because as Malcolm highlights, currently the High Court and solemn courts are working at capacity in terms of the work that is already there. With the cases that we currently have in our system, both in the High Court and Sheriff and Jury, if we wanted to ensure that they did not time bar on the 30th of November, we will have to almost double the amount of cases that we are going to indict into the High Court each month from February to October. Now, that will remove the risk of them time barring, but will simply be moving the caseload into a system which is already working at capacity. It will not mean, and I know Kate Wallace highlighted this in her evidence last week, it will not mean that cases will be dealt with more quickly. It will inevitably lead to delay as pressure is put on various parts of the system, including SCTS and Scottish Prison Service in relation to the amount of work that is there. So that's a work in relation that we're doing in relation to the planning and the discussions we're having to Scottish Government in terms of just the cases that are in the system and providing the extension to those cases that are there so that we can manage that caseload. The other consequence of that would be effectively, as we move towards the end of the year, resource will need to be redeployed from trial courts to have daily extension courts where we will have to make applications to the court to extend time bars. The court will require to have a judge or a sheriff. The defence will require to be in those courts to argue those extension to time bars, which will simply be moving resource away from the trials that are required to run. I heard the evidence last week, obviously the concerns from Law Society and the Defence Bar, and we would welcome a discussion with them, and we'll speak to Law Society so we can outlay the impact for the system, but also across the criminal justice system, including accused and defence agents.
Do you want to come back in, Malcolm?
Yeah, I mean, I don't disagree with anything Laura said. Just a slightly more optimistic, I suppose, picture for the longer term. He said, well, what's to be done? To some extent, I would hope that this will be a transition issue as we move towards the proposed sexual offences court that's in the other bill that I referred to earlier. And ultimately, that's proposed to be the solution to dealing with this sustained increase, which continues to grow, of serious sexual offences, which rightly, and through a whole series of policy interventions and legislative changes, as well as cultural and practice changes across all the justice organisations, there continues to be a redress of the past, along with a greater level of identification of current crimes. That's going to continue. We can predict that now. It's a good thing for society, but it puts pressure in the system. And at the moment, without preempting the will of Parliament in terms of the Sexual Offences Court, we have to deal with that increase of mainly sexual offences cases coming into the court. They tend not to resolve prior to trial because of the nature of them. and there are other things that we've put in place for very good reasons, which we're very supportive of, that take additional resource in terms of dealing with vulnerable witnesses, taking evidence by commission, judicial time into those elements, all of which is very positive. But that needs to be recognised in terms of the size of the system that deals with it. And I said when I was here in the tail end of last year, that if there's going to be budget changes across organisations, then it needs to be done through the government recognising balance in the system. And the Crown have received an uplift to their budget, which I think is going to, at least in part, facilitate some of the work that Laura alluded to. SCTS and some other parts of the system, didn't receive an uplift. So there isn't the capacity to increase the High Court system in the short term. But I have great hope and ambition around about the prospect of the Sexual Offences Court as it's proposed in the other bill.
That's very interesting. I'm grateful to you.
Okay, thank you. And very briefly, Pauline McNeill, and then we will have to move on to part two.
Yeah, thanks. It was just to cover national jurisdiction that we haven't covered. I'll try and do my best to be brief. So, on first reading of the bill, in my line of questioning last week, I've established that the national jurisdiction question is quite separate from the virtual custody. And initially I thought, well, that would sort of make sense if we're talking about trying to deal with custody courts. But on second reading, there's a bit more to it. So the Lord Advocate will decide the jurisdiction. So that's quite a difference from established legal principles in Scotland, and that sheriffs can sit in any sheriffdom. But subsection 6 and 7 essentially amount to, this is what I wanted you could help me with, going further than that. I'll just read it out. Is that helpful? Subsection 6 allows the proceedings to go beyond until the conclusion of proceedings unless they come to an early end. And in petition cases in particular, which I'm interested in, proceedings on indictment, subsection 7 says a court which began dealing with a case at petition can continue to deal with it. In practice, because jurisdiction under subsection 5 ends with an accused being fully committed to trial. I mean, I presume you had an input, I presume the Crown Office had an input to the bill, I'm presuming that, in the writing of the provisions. So I was just trying to understand why you would want to go further, because it just seems quite a lot of additional change. Sheriffs can sit in any sheriffdom. The Lord Advocate, unless that could be challenged, will decide the jurisdiction anywhere in Scotland, but will go beyond the custody courts. I put this question to the Bar, Scottish Bar Association last week, because I was struggling to understand it, in all honesty. But they have confirmed they have got a bit of a concern about that as well. But anyway, I just wondered, could you speak to that at all? Is that possible?
So I'll try and cover that. Firstly, it's not new that the Lord Advocate determines jurisdiction. That's long-standing. The prosecutors will ultimately depend. Well, there's multiple cases and it's across, so we do that. Mm-hmm. And again, I think from discussions with our colleague, we saw this raised last week in discussion in the Bar, and we agreed that there's probably some further work we can do in discussion with Scottish Government about May, because the reality is we will almost always want to prosecute in the jurisdiction in which the case the crime has been committed. It makes sense if witnesses are there, if the accused is there. Again, I suspect the word may is there to have flexibility. If there is an occasion where the solemn case may require to stay out with the jurisdiction. The only example I can think about that is we do already have provision. So, for example, if a sheriff was a victim of an offence or a fiscal that's in the court was a victim of offence, we can transfer that case to another jurisdiction to ensure that it's dealt with. So there is provision there for that to be done. But I agree that there is some further work we can do in discussion with Scottish Government just to get some clarification of when is that intended to be used, because it would call on petition in any court, but then we would almost always be looking for it to be transferred where the case would be prepared. I don't know if Malcolm, you've got any views on that part of the bill.
Yeah, I mean, hugely supportive of it. As it currently stands, it's used to good effect for, you know, things like transport disruption, severe weather where we can, other public health emergencies. And there's also an arrangement being put in place with the current provisions for people who are being transported on warrants from England and Wales to come and appear at Dumfries, which is really a kind of human rights-based issue, as opposed to taking people to Inverness or Aberdeen, which might have been the jurisdiction of their offence, when, you know, they're not going to be held in custody, etc. So there's all sorts of, you know, practical but actually human rights-based decisions being made in terms of using the national jurisdiction. And I think in the main, the benefits from the SCTS perspective, as contained in the written submission, is round about custody cases and the flexibility for
I agree with that. I mean, but that's why I'm concerned about that section. And I'll be honest, I mean, it just looks like, oh, we'll just take all these powers just in case we need them. But as Katie Clark says earlier on, I mean, your assurances are really helpful. But at the end of the day, you know, we've got to deal with the black letter of the law. And as it stands, I'm not entirely comfortable with a subsection that just says that only one person decides that in the letter of the law, and you can just take it in any court. I would want some reassurances that some pleadings could be made to apply the same common sense as we've had all along, because there's special reasons. But this bill really opens up quite wide. So anyway, thank you for that.
Thank you very much. So I would like us to move on to part 2 of the bill. And I'm going to bring in Detective Superintendent Adam Brown initially, and then I'll come to Emma Forbes. You've been waiting patiently. So I suppose my question is really the same as as my introductory question for part 1. Obviously, the bill sets out a sort of framework for a system of domestic homicide and suicide reviews. So I'm just interested in your general comments on this provision, what you feel is welcome. Are there issues or concerns that you have? So I'll just come straight to you, Adam, and then I'll bring in Emma.
No, good morning and thank you. Broadly, we're very supportive of the principles in the bill and introducing a model that looks at learning across agencies when domestic abuse has resulted in a death. We're committed to helping develop the model. Our Head of Public Protection sits on the task force. We're sitting in the task and finish groups in terms of that development. So we are embracing that process of development as well. We're keen, as I'm sure all of our partners are, that the model, when it lands, is robust, it's fit for purpose, and it does encompass the principles of being person-centred and trauma-informed. But we're also keen at the point of implementation that we're well prepared in terms of our readiness, our processes, our resourcing, our guidance and our systems. And my colleague Richard mentioned earlier on some sort of more recent examples where we've perhaps had something implemented and we're still waiting for that to sort of bear fruit years later. Given the potential scope for deaths that could be considered for review, and the fact that the definition of a relevant death may expand in the future, as per the provisions in the bill, there are some observations that this state of readiness may be a challenge, given the potential timescales. In respect to the domestic abuse-related suicides, as a notifying body, we would welcome a clear understanding of expectations in relation to there being a demonstrable link between domestic abuse and a subsequent death. Currently, the proposal includes deaths where domestic abuse may be a contributing factor. The explanatory notes do speak about causality, but it's not particularly clearly defined, which creates a very wide scope for deaths that could be considered subject to review under the model. The impact on Police Scotland budget and resources could therefore be significant. It could create challenges in participating appropriately in reviews without impacting service delivery elsewhere. As my colleague Richard rightly pointed out, we are at an early stage, so in terms of the development of the model and exactly what that looked like, it's even less possible to be sort of prescriptive around costs and resource and demands. But the financial memorandum that accompanies the bill is silent on the anticipated financial budget on the police, the anticipated financial impact on the police budget. Whilst development of the model is very much ongoing, we would welcome further consideration of how the provisions for the model will be appropriately funded and capable of being given operational effect within the expected timescales.
Okay, thank you very much for that. And I'll just come straight to Emma Forbes just for some general comments.
Like our colleagues in the police, Crown Office and Procurator Fiscal Service support the introduction of domestic homicide and suicide reviews and the placing of those on a statutory footing. I would ask the committee, though, to remember the first principles of why we want to introduce these in the first place. So we are working from the premise that we can learn from horrific, tragic circumstances to try and prevent them happening again, and to do that in a way that's non-biased, blame-free, victim-centred. In Scotland, we have a different and unique definition of domestic abuse than any other country or jurisdiction worldwide. And I fear that this Part 2 of the bill borrows too much from other jurisdictions, when, in fact, we should be setting our own path. So the Domestic Abuse Scotland Act 2018 defines domestic abuse as being between partners and ex-partners and the children of that relationship affected by that abuse. It is a clear definition and it recognises the dynamics of intimate partner abuse in quite a brave way, because there's no other jurisdiction in the world defines it in quite the same way. The definition within the Act for domestic homicides is much wider than that, but also, more concerningly, gives the Scottish Government the opportunity to extend it further at a later date. And we're really concerned about that, because the definition is also in the joint protocol that we have with Police Scotland for all of our operational investigation and prosecution of domestic abuse. It is the foundation of Equally Safe, your own government policy. We're just concerned about inconsistent government policy here and inconsistent definitions. It really matters that when we're talking about domestic abuse, we're all talking about the same thing. And in Scotland, we recognise that that's intimate partner abuse. Now, not for a minute do the Crown suggest that that means that these other deaths should not be investigated. The Lord Advocate is responsible for the investigation of all sudden and suspicious deaths, and will consider whether there should be a fatal accident inquiry or a criminal prosecution. We have a bereaved families charter that sets out the Lord Advocate's commitment to bereaved families. So if somebody dies in tragic circumstances, that death will still be investigated, that individual death. But what we want to do here with domestic homicides is learn how we can prevent predominantly women and children dying in their own homes within a domestic relationship. And I fear that this bill goes further than that and dilutes it. Now, if you look to England and Wales, because that's what the drafters have done, then let's look at the evidence of how it operates there. And we can see that just under half of their domestic homicide and suicide reviews related to intimate partner relationships. Many of them were extended family, other children staying in the household, adult children. So less than half are what we actually mean by domestic abuse in Scotland. And that's a large number, and we've just heard from the police about the impact of the large number and how we could possibly do justice. So in considering how we would finance this, we also have to think that if we want to be trauma-informed and we want to do justice to these families, deal sensitively with them and pay tribute to the memory of those that they have lost, then the budgeting of this should not just be about how much it costs to run the reviews and for us as organisations to conduct review panels and investigations. It should be about what we do with the learning afterwards. It has to be about a proper infrastructure that means we learn from those and that we listen to the feedback. And unless we can afford to do that properly, we shouldn't be doing it at all. So we completely agree in principle with having domestic homicide and suicide reviews, but we would ask that the globally recognised gold standard of domestic abuse in Scotland is respected and that the definitions are tightened up within the bill.
Okay, thank you for that. And I know other members are quite interested in looking at the points that you've made around definition. But you spoke there towards the end, Emma, about the review process, and obviously the bill is proposing, I suppose, two tiers, if you like, the Review Oversight Committee that would make that initial assessment and judgment, presumably, about which cases then go to a case review panel. And that sounds relevant to me, given the kind of expanded potential number of cases that might fit within this provision. I'm just interested in maybe hearing a bit more about your thoughts about that proposal around having that committee and review panel arrangement.
So you're fortunate to be hearing from Professor Devaney after us, and based on the previous research, he had suggested having the Oversight Committee, which we welcome and think that that's really good because the independence of these committees is key. One of the key learnings from England and Wales is that it's very difficult for review panels to remain independent when... So in England and Wales, it's done police force to police force. In Scotland, we have one police force, we have one prosecution. We're a small nation, and it's, if we're being realistic about it, it's going to be the same Kent faces on each review panel. So having independent chairs and an independent oversight committee is fundamental because it ensures that it's community collegiate learning that's not blame-based, that's non-biased, that really helps us to learn for the next time. But I don't think that that in itself is enough of a safeguard against the broad definitions. And we're concerned about the lack of definition of what's meant by a domestic suicide. We're supportive of them being included, but would like some clarity on really the causation. We would, as prosecutors, want to be satisfied that there was a causal link, that mainly because domestic abuse is a continuing offence in almost all cases. It's not one discrete incident. And so I think if suicide is going to be included, it should be because it's part of the abusive course of conduct. And in many cases it is. And we can establish that, and they should properly be within the review. But parameters are important.
Okay, I'm going to bring in Rona Mackay and then Ben McPherson.
Thank you. Good morning, panel. Can I come to Emma, please? Emma, you've answered most of what I was going to be asking you, but with your vast experience in domestic abuse crimes and your commitment to it, I just wanted to clarify if you think, I hear what you're saying about you don't appreciate the widening of the bill to extend the definition, and I understand all that. Do you think the bill as it stands kind of dilutes the 2018 Domestic Abuse Act,
Yes,
even as it stands?
That's what we're worried about at the moment. Now, I appreciate that there's provision in the bill for the government to extend the provisions, and that there is an intention that eventually it would include near misses, which is a separate concern of the Crown because of the vast numbers and the dilution of the intention. But right now, as it stands, if you have somebody who is murdered in a domestic relationship and somebody where an attempt is made on their life in a domestic situation, a different definition is going to apply as to whether or not that's domestic abuse. We need the same definition. It shouldn't matter whether you live or die. You should be able to know that there's one definition that everybody understands. It's about access to justice, transparency, fairness, everything that we've been talking about this morning.
Thank you. You put that very, very powerfully. Can I just then quickly, I know we're running out of time. Section 25 of the bill refers to the Scottish Government. It proposes the Scottish Government issues written guidance on how review bodies should carry out their functions. What do you think of that, and do you have any views of what should be included in that guidance?
So we think that that's helpful, and hope that it would give some direction as to the make-up of the review panels and the independence of chairs and the independence of the Oversight Committee. But we don't want to have to rely on that. We would like to see the rest of the bill more tightly drafted.
Yeah. Okay, thank you. Do you want to comment, Laura, on anything? No. You're fine. Right, okay. Thank you. Thank you, Convener.
Okay. I wonder if I can sort of flip this kind of question round a wee bit with regard to the sort of scope of the review and ask if there are types of relationships that are not included that you think should be. I suspect from what you've said already the answer is no, but it's maybe something that's worth just asking about.
I think if the committee feels that there are other relationships that should be included, then it would be appropriate to go through the procedure of considering whether the definition in the 2018 Act and within our current policy and law is adequate, and if not, to seek to change that, rather than having two different definitions and a muddled understanding. Yeah. I think that we should, and the Scottish Law Commission is currently looking at civil remedies for domestic abuse, and I've been part of the advisory panel on that, and we have discussed exactly this, the importance of a common definition, and that's one of the matters that they're consulting on as well. We are just keen to ensure that there is a common understanding.
Yeah, thank you. Okay, thank you. I'll bring in Ben McPherson.
Just very briefly, if I may, Convener, on not on part two, but just on part one, there was something I meant to ask about digital productions that we didn't get to. I can do it at the end if you'd prefer, or it's fine.
Just carry on.
Thank you. Just something that came up again last week when we were speaking with our witnesses. Then there was some discussion around when an image is used instead of a physical item in evidence. Will this item be retained to allow the defence to access it? And where it is retained, how long will it be kept for example, until the case is concluded and any appeal is dealt with? It would just be good to get any feedback on those points.
Yeah, thank you. I saw that as well, and it did raise a few questions, and I was speaking to Laura about it earlier. The question was around if a defence agent would want to, say, the example of a knife being used is the classic. So if a knife is used in a crime and it's digitised and the digital image is best evidence for the purposes of court, however, a defence agent might want to examine the original article, may want to have it forensically examined, and so on. The question being, well, why don't we just keep it until the end of the trial and potentially until the end of the appeal? The concern that would arouse really is, well, what it kind of defeats the object of the purpose of having items digitally captured, because it still requires for some physical productions to be retained with all that entails around time and storage and everything else. And I think that it could be facilitated, and probably would be in some cases where a digital item produced in court, the original would still have to be retained for a period of time, and that would clearly incur questions around the existing processes and procedures. Would they need to be reviewed? Probably, nevertheless, I think that the benefits would be that we retain a huge number of physical productions that are never going to come to court, are never going to see the light of day, and that there would still be the opportunity there to digitise those in the event that they're required, and free up an awful lot of storage space that would otherwise be kept. So I think it did kind of raise a wry smile a little bit when I heard that, and the suggestion that, well, let's just keep it. But I think on balance, the benefits would still arise because of the ability to dispense of an awful lot of stuff that we keep that we don't really need. Mm-hmm. Hopefully that answers the question.
Yeah, it's helpful feedback to have heard both. And
perhaps if I can just quickly come in, I appreciate the time, is that, again, I suppose it's back to the discussions we had. There is protection built in the bill to overrule the presumption. So if the Crown or the defence say, no, we want that physical item in court, that it would be available for the court, and there would, of course, be the opportunity for the defence to examine or forensically examine an item. So there may well be a difference. For example, if the police go into a house and they seize 25 knives, there may be no requirement. The defence may be content with the pictures of the knife, the evidence of all the knives, that's more than sufficient for court, and it means that there can be an agreement and that the knives don't need to be required. It may be different if there is a knife and it's an assault, and the Crown may wish that evidence in court, and the request will be for the court, and ultimately it will be up to the court.
But it is a good example of the kind of question that remains unanswered at this point, that while, in principle, the idea of digitising evidence is really supported, there are still questions around practicability in certain instances like that.
I mean, is there obviously you're much more experienced in these matters than I am, but just from what you've said and what we heard last week, perhaps I'm wondering if there's a compromise position of, say, for example, within 3 months of the date of charge, could there be an opportunity for defence solicitors to examine it or to make a decision before the physical item is then destroyed and the photographs are then used? Is there further consideration that we need to give collectively?
There's more work to be done, I think, is probably the answer.
Okay, thank you.
Okay,
Thanks,
thank you. I'm just aware we have run over time a little bit, but I think it has been a really important session just to let run. I wonder if I can maybe just ask a couple of final questions with regard to Part 2. Now, obviously, the bill within Part 2 allows reviews to be carried out in parallel with other proceedings, namely criminal proceedings. However, the Lord Advocate would have the power to pause or to end a review process to prevent prejudice in other proceedings. I'm just interested, and I'll come to perhaps Laura and Emma, I'm just interested in your view on that provision.
We welcome the provision in the bill. We have been very supportive of the concept of having the domestic homicide and suicide reviews, and we are keen to support those. But there will be occasions where there is an ongoing fatal accident inquiry or an ongoing criminal prosecution that may be prejudiced by the review running in tandem, and there may be occasions where the Lord Advocate may need to use that power, so we would welcome it.
Okay, thank you very much. Laura, anything quickly?
We do successfully, though. We have child death reviews, and they can have similar issues in terms of there may be a criminal prosecution or there may be other investigations, and there are protocols about evidence sharing and the understanding of when there are situations where the reviews may need to pause to allow for those procedures to take place. So we do have a good grounding for knowing how it would work in practice.
Yeah, okay, thank you. That's helpful clarification. Just one very final question. I'm going to come back to Detective Superintendent Brown. And in the police submission, there's reference to Section 20, which places a duty on the Chief Constable to cooperate with the sort of review process, and there seemed to be a little bit of concern raised about that particular provision. So I just wondered if there's maybe a wee bit more that you would care to share just on that particular point.
I wouldn't have said there's a concern about having a duty to cooperate or partake in views or share the information that's required of us in respect of the reviews. I think the concerns relate more around what that participation and that duty to share information looks like. So you mentioned earlier on 2 tiers. I would probably submit that there's a 3rd tier, which is that preceding notification process. And some of the concerns really relate around the potential demand as well as what we put in place in order to implement that in terms of guidance, training. Having reviewed the financial memorandum, without being able to be forensic about it, I think the estimation of deaths that may fall under the scope of being classed as reviewable is probably underestimated.
Yeah, okay.
And the concerns would relate more around how we deal with those challenges.
Yeah, Okay, thanks for that. And I think, Liam, you want to come in with just a very quick
Yes, very
follow-up,
quickly. Just
and then we'll finish.
Emma Forbes, if I might direct this directly to you, just so I'm fully understanding what you were saying to us earlier. I think your concern is that the Section 9 definitions in the bill are different from those in the 2018 Act, and therefore, given that, and you mentioned something about amending the 2018 Act, but this is the bill we've got before us. So is what you're telling this committee that this committee should at least consider porting the definitions from the 2018 Act into here to ensure consistency?
Yes, that's what we would like to see, yes. The 2018 Act defines domestic abuse as abuse between partners and ex-partners, and Section 5 of that Act includes children of the relationship who are affected by the abuse. And that's the definition that's employed in Scotland, but also globally, worldwide, we are the 2018 Act is recognised as the gold standard because it recognises the unique dynamic of offending between partners and ex-partners in that intimate relationship that is not... It's difficult because when you read the Act, you see that, of course, these other people may be affected by the domestic abuse, and that's not to be refuted. It just reminds us that the ripple effect of domestic abuse and the fact that it can affect so many different people, and it will affect friends, family, those visiting the house. The children on a play date was the example given in the explanatory notes. It will affect women in making decisions about whether or not to go, young women on deciding whether or not to go on a date, when they feel safe, when they don't. It affects the whole of society. It really does have a ripple effect. And in any occasion where there is criminality that affects those individuals, we will investigate and prosecute. Where there has been a death, we will investigate. But that doesn't mean that the fact that they have been affected by the domestic abuse does not mean that they should be included within the definition of it. And the definition in Scotland is tight. And other jurisdictions look to us and say, actually, you've been brave and you've recognised that there is a unique dynamic between couples in a relationship. And the 2018 Act privileges that. And I fear that this may dilute Scotland's whole approach.
I understand. Thank you.
Thank you very much. Okay, thank you very much indeed. We've massively run over time, but I hope that's been worthwhile. So thank you all for your attendance today. And we'll just have a short suspension to have a changeover of witnesses. Thank you. Thank you. Okay, thank you very much and welcome back everyone. So we're now moving on to our second panel this morning, and I'm very pleased to welcome Professor John Devaney at the University of Edinburgh, Professor Neil Websdale, Director of the Family Violence Centre at Arizona State University, who is joining us remotely. So a warm welcome to you, Professor Websdale. Hopefully you can hear us loud and clear. And Dr Grace Boughton, criminologist. So thank you all for attending today's meeting, and apologies for the slight overrun of the first panel. And also thank you very much for your submissions from Professor Devaney and Dr Boughton, which have been circulated ahead of today's meeting. And thank you in particular to Dr Boughton, who has travelled from England to join us this morning. And as I say, Professor Websdale is joining us from Arizona, where I believe it's maybe 4 a.m, 5 a.m. in the morning. So if you disappear for another strong cup of coffee, we'll understand why. So thank you all for coming. And I'm going to allow up to 75 minutes for this session. Before we move on, I wonder if I can just propose to members that in order to allow enough time for this session, that if required, it will defer our private session, our review of evidence from today. So we'll just see how the timing goes. So I wonder if I can just start with a general opening question on part 2 of the bill, and that obviously sets out a framework for a system of domestic homicide and suicide reviews. And hopefully, John and Grace, you've been able to listen to some of the earlier evidence that we took on part 2. So I'll come to John and then Grace, and then I'll bring in Neil after that, just to ask what your general views are on the principles of Part 2, that is, of having a statutory system of reviews in this particular area. So over to you, John.
Thank you very much, Convener, for the opportunity to come along today and address the committee. Certainly, I think there are many benefits of having a statutory review system around these matters. One, that it creates a legal framework in which there is both clarity for individuals and agencies that might be contributing to a review, but also for the families of victims. It allows them to have confidence that this is an important matter to be taken forward. There are certainly lots of mechanisms in Scotland in terms of looking at culpability and in reviewing matters through the criminal justice system and through professional regulatory bodies. But what's being proposed is very much a system that will help services and organisations reflect on the learning that might arise whenever any of these terrible tragedies happen. In Scotland, there are at this moment in time relatively few. But when we look back 30 or 40 years, there were many more. And I think that's a credit to the processes that have been put in place in Scotland. Strategies around Equally Safe and the various iterations of that, to try and think about what are the suite of ways that we can understand these issues, and also what are the services and responses that we want to have in a way of trying to reduce deaths, but also ensuring that we provide support to those who are victimised, both as adults and as children. And I think learning reviews are a really crucial instrument in all of that, and we see that in those jurisdictions, which aren't many internationally, and Neil can probably speak to this well, where those mechanisms have been put in place, they do provide an opportunity for services to do their own reflection alongside actually sharing their own reflection with other agencies and services in a way of trying to have a much more joined-up approach to how we address this issue.
Okay, thank you. And I'll maybe come back with a question on sort of learning lessons in a moment. So I'll come to Grace and then to Neil.
Thank you, Convener, and thank you to the committee for having me today. I am in full support of the Scottish Government and Parliament going forward with having domestic homicide and suicide-related reviews. And I think having it first and foremost within the legislation, so having that legislative footing is really important, because as you're aware from the wider remits of this bill, there's a lot going on in criminal justice, in other areas of work as well. So having that legislative footing puts it in, you know, it has to be done. It becomes a mandatory thing for agencies to be involved in. What I would like to highlight, though, is that although the statutory footing is important, it's then the minutiae of the reviews, how they're going to be conducted, who's going to be involved, what type of approaches are going to be taken, that is really important for this, because ultimately that will contribute towards those recommendations, those lessons learned. And that's why these reviews are in existence across, you know, other forms of the UK and elsewhere, is to learn from these reviews and learn from these cases and hopefully reduce the amount of homicides and subsequently suicides, which have also been included in the scope in future, which I can expand upon later.
Okay, thank you. Okay, I'll bring in Professor Neil Websteel, so hopefully you can hear us okay, and we're just interested in your initial thoughts on the proposals around the Domestica homicide and suicide review process.
Well, thank you very much for inviting me and involving me in this process. I've had the pleasure of working with some of the folks who've put this together, and I'm impressed by the level of detail and the sort of comprehensiveness of the discussion, and I am also in favour of the bill, although I recognise, as our friends from the law enforcement community have said, and as Emma Forbes has mentioned too, that there are some definitional issues that perhaps are challenging, both practically and in terms of you know, the fiscal implications. But broadly speaking, I think these homicide reviews and suicide reviews have occurred in functional democracies, starting in the United States in the 1990s and spreading to Canada, Australia, New Zealand, UK, and a number of other functional democracies. So I think to keep the big picture in mind is very important. The intimate partner question in Scotland is obviously of key significance definitionally, but I think too we must recognise the complexity of these relationships and how challenging they are. And one of the things that has impressed me over the last 30 years or so of practically doing these reviews, of serving on teams, is how the reviews, if they're done well, get at the complexities of the relationships and the compromises that both victims and sometimes perpetrators face in their lives as they move towards making these decisions in their lives. So I favour a broad-based, wide-angle lens approach. I favour, you know, using a large number of witnesses, but I also understand the fiscal complexities, the practical complexities of that. So I'm broadly in favour of the process if it's done well. But I've seen a lot of situations internationally where it's not necessarily done well, and I admire the careful approach that you're taking. I think that's very wise. Thank you.
Thank you very much, Neil. That's some helpful opening comments. I'm going to try and maybe link the issue around, or the point around learning lessons and what perhaps the experience of other jurisdictions is. So I'll come back to John, and then I'll maybe just jump back to Neil. So I suppose the question is about, when we're thinking about learning lessons, are there experiences of similar systems of review in other jurisdictions that can perhaps inform where we go in terms of considering the learning process out of the review provisions. Do you think that the bill perhaps reflects what is necessary in that space, if that makes any sense at all? So, John, I'll bring you in first.
It's a really good question to ask because I've had the fortune of being involved in developments and discussions over the past 18 months. And when I became involved, one of the things I raised was that there's a danger in developing a system that you think of the review as a standalone thing, that it's only about sort of getting people together, analysing some information and writing a report, and in some way that the learning will automatically flow from that. Well, actually, when we spoke to people like Neil and other people who have been involved in this work for much longer internationally, and we did look internationally, including across the other 3 jurisdictions within the UK, what came out very clearly was that if you don't have a system at the end for taking forward the learning and give that as the same level of attention, then actually there's no point in doing the reviews, because then they just become something which is very costly. There is a danger that they detract in terms of professionals getting on with their day job, and actually there's not an avenue or vehicle for them for that learning to be both disseminated and incorporated into practice. Because at the end of the review, there's likely to be 2 things arising. One are a series of recommendations that are directed towards particular agencies about what they might do going forward that could strengthen what they're doing. And there's lots of examples of very good practice in Scotland already. So it's not about trying to in some way cause agencies to think that they're not doing a good enough job. But what we do know is that we've seen improvements over the past 30 years. There's likely to be further improvements over the next 30 years. But unless we have ways of trying to identify that, it's hard for systems then to incorporate that into what they do. So there's actually likely to be recommendations, and there needs to be a mechanism for taking that forward. And if agencies aren't in a position to be able to take that forward, what's the mechanism for them to account for that or explain themselves? And there may be very good reasons for why a recommendation can't be taken forward, but for family members who are left behind, they need to understand that, as opposed to thinking that a review's been held, things will change, and then not seeing any change or enhancement to frontline provision. Second thing, separate to recommendations, can be learning. So this is something that may be less tangible, that can't be turned into a recommendation, but could be about encouraging both individual practitioners or professions or organisations to think about how they go about their business in a way which is more joined up. Some of that can be translated into recommendation, but quite often it's about raising awareness and understanding of the complexity of domestic abuse. And we've seen that happen. When I trained as a social worker 40 years ago, if we talked about it at all, it was very much about physical abuse and about incidences, whereas now we sort of have a much broader understanding about what is domestic abuse, and that it can be incidences, but it actually can be a whole series of conduct of behaviour and about sort of an atmosphere that's been created, and that is learning that we have gained over time. And so therefore I think that we need to ensure, and I think the bill does try and put in some of the architecture for that, so that actually reviews individually can be brought together by the Oversight Committee, and that the Oversight Committee has a legal responsibility now to have mechanisms in place to ensure that that learning and those recommendations are taken forward, and that as a society with better understanding, but also that organisations do feel as though they've got to account for what they do on the back of a review having taken place.
Okay, thank you. I was going to come straight to Neil, but I think I'll maybe bring in Grace. Obviously, you've come from south of the border to join us today, so you may have some reflections on what perhaps we can think about in the context of elsewhere in the UK, as well as a sort of wider international picture.
Yeah, definitely. So when it comes to, for me, the recommendations and the outputs are one of the most important things of these review processes. And I think that is perhaps a challenge that's been experienced south of the border. So I think it's been an issue that England and Wales have been grappling with, particularly if you have the same recommendations that are coming out of each individual review over a period of time. So I really liked the inclusion of periodic reports within the bill. I thought that was really interesting. And I wasn't sure whether the Review Oversight Committee were going to have a part within that particular process as well. I think they'd be perfectly placed to help with the recommendations and the holding to account part of the process. And I think John's completely right with regards to holding organisations to account with regards to how far they've progressed with changes or recommendations, why it has perhaps progress stalled, because I think that's something that can be left and grow into the weeds if no one's holding them to account and looking over that. I think what could potentially help here, and what England has and Wales, which I've put in the submission for you, is a repository system. So where all reviews are collated and hosted. England have the Domestic Homicide Review Library, whereas Wales is slightly different. It's going to be a safeguarding repository that's closed access, whereas the English one, anyone can access via the Gov website. So I think that also having that there will help with the holding to account measures and seeing what's going on. I think ultimately the biggest challenge you kind of have in this arena is that the progress we want as a society and as professionals that we're looking at is for a reduction in homicides and suicides. So ultimately, knowing whether something's going to have a direct impact as to whether someone doesn't take a life or doesn't take their own life is going to be incredibly difficult, if not near impossible, to measure. However, what you can do is if you put in mechanisms and stringent oversight over these recommendations, you can at least develop some sort of correlational evidence, hopefully, to see if one has impacted on the other. Yeah, I think that those would be my main comments with regards to that.
Okay, thank you. And I'll bring in Neil just again on the broad question about lessons learned and perhaps specifically a question within that about timescales. So, you know, once we have, if you like, undertaken or completed the learning process, should there be timescales applied in terms of how those lessons are applied to changing practice? Example. So, Neil, over to you.
Thanks. In terms of learning and the implementation of recommendations, this has been probably one of the central issues with doing fatality review, homicide review, not just in the United States, but globally, everywhere. First of all, it's hard to implement recommendations. And Dr. Boughton is absolutely right that we can never show that something didn't happen. There wasn't a killing because of the impact of homicide review. We're never going to be able to show that. The correlational data is important, but one of the things that struck me is that it might help to have more feedback loops with regard to the recommendations and the findings. So there are some jurisdictions in the United States historically that have reviewed cases and then convened focus groups or listening groups of, say, survivors of domestic abuse in order to get some feedback on the appropriateness or the potential relevance of draft recommendations. In other words, how meaningful is this in terms of our lives? And I thought the language of the legislation in general, the bill, the movement through, would have benefited from a little bit more in terms of feedback loops, what we need to look for. And you may want to extend that even more broadly. And I think this is a question of encouraging teams to become a little bit more granular. And in the United States, Clearly, advocacy organisations, shelters, domestic violence programmes, whatever, have listening groups of survivors. So it's not that difficult, and they often feel empowered is perhaps too strong, but appreciative of being asked. And I think a really important piece to bear in mind is that these reviews are about, in some ways, confronting democratic backsliding. So that aeration of reviews and the deliberations of the groups with community members and others who are perhaps lay, not professional people, is important. In the United States, in terms of learnings, we've clearly learned a lot about the role, for example, of strangulation or serial strangulation in dangerous, severe intimate partner violence cases. The point that Emma made earlier, Emma Forbes, in terms of, yes, we prosecute the dangerous cases, yes, we want to do that, is an important one, but the research is clear that there is also a lot of domestic violence, domestic abuse, that does not rise to the level of what some researchers would call either intimate terrorism. My old colleague Evan Stark referred to as coercive control. The majority of the cases don't rise to that level. And what we found is that the domestic homicide reviews have been quite discerning in terms of teaching the community, public education, but also on a broader level, cultural change, in terms of speaking about the things that we need to pay attention to. So, for example, the police in England have worked some marvellous large data sets. Sarah Thornton's work is one example. There are others that talk about now the emerging role of suicidality with offenders. And I think traditionally we've had this sense of offenders use their power and their control to, tyrannize and domineer in these relationships. And this is, of course, in some ways, an aspect of these relationships. No one wants to deny that. But one of the things we see when we interview perpetrators in prison, which is a very important piece of these reviews, we need to access their perspectives. We see a powerlessness and a vulnerability in many of these cases on the part of the perpetrators too. So the reviews have taught us to appreciate a more rounded set of interpretations in these cases. So that is a public learning that matters, and it speaks to the issue of cultural change. If these men are just seen as powerful and controlling and domineering, we miss the opportunity culturally to frame them as dependent, vulnerable, in many cases, bullies. And this is to, obviously to exclude the psychopaths or the antisocial personality disordered people. They're a little different. But anyway, I digress. The suicidality and also the seemingly counterintuitive behavior of victims. As victims move through these cases and navigate systems, we need to know how they perceive systems. It doesn't matter if we think we're offering this array of services here and there and this and that. What we need to know is how victims make decisions, how perpetrators make decisions. And the reviews, if they're done well, enable us to look at those compromises and appreciate the seemingly counterintuitive behavior of victims. And this is something we have a major problem with in the criminal justice system. And without police training in the United States, we've spent a lot of time working on that risk assessment interface. It's not just a question of asking, what are the risk markers? It really is an issue of how we do this. And that's where the system can benefit from the reviews, I think. And I will leave it there.
Okay, thank you. Some really interesting points. We're maybe slightly straying off the provisions, but helpfully circling them back to the review processes being proposed. So with that, I'm going to bring in Liam Kerr.
Thank you, Convener. Good morning, panel. Professor Devani, you heard Emma Forbes earlier of the Crown Office raising concerns about the definitions in Section 9. She seemed to feel that not using the same, not correlating with the 2018 Act could lead to issues, and in any event, the definitions that we've been presented with might need tightened. Would you give us your view, and what should this committee be doing?
Yeah, it's a very valid and important point that Emma's raised, and certainly we don't want to do, I think, a bill is, shouldn't be anything that the bill does that seeks to undermine what is the commonly understood definition of domestic abuse within Scotland, albeit that we should also be mindful as to what the reviews are seeking to achieve, which is seeking to identify learning that can resource the wider systems and supports around victims of domestic abuse, and they can't be seen in isolation. We do have instances whereby if we stuck tightly to a definition which was only related to domestic abuse as it's defined in the 2018 Act, one of the unintended consequences is that you might have somebody who was killed along with somebody else in the same incident, and therefore only one death would be looked at in that context rather than 2 or 3 or 4. And I think that would be hard to actually explain why that would be the case to a layperson, let alone sort of the victims' families. I think the other side is that within Scotland, one of the limitations of the current definition is, and it's recognised within this bill and the explanatory notes, is that in some communities within Scotland, both new communities and communities that have been here for a long time, actually what we mean by family and in terms of sort of what might be seen as honour crimes could end up being excluded from being reviewed, and I don't think that's the intention. I think the intention is that actually when we think about domestic abuse, we don't just think about what are very Western ideals of what makes a family and what is sort of an important relationship in somebody's mind. The reason I think the scope is broader than the domestic abuse definition is that there was a consultation exercise which took place with both services and also with those with lived experience of domestic abuse. And it was actually many individuals with lived experience who were saying, well, actually, if you just limit it to the definition of domestic abuse that's in the current legislation, actually there could be a lot of learning that's missed. And if we're really trying to strengthen the support around victims and victims' families, we need to be more mindful of that. One of the things we've learned from other places where there are domestic fatality reviews is about the number of women who are killed by adult sons. That's not one of the things that's proposed at the moment within the legislation, but actually looking further afield in Scotland gives us a sense of where there might be types of deaths that actually aren't covered by any review system at the moment, but do happen within the context of family relationships. And so I think it's a balancing act, of the one hand, not undermining the definition in Scotland of domestic abuse, but trying to think about not being so constrained about that we don't generate learning that will be important in terms of how we move forward.
Thank you. So just so I'm very clear, are you fairly comfortable then with the Section 9 definitions as they are presented to us?
And I do think that the statutory guidance, and I think that the work that's done around that can definitely support people to say that this isn't changing the legal definition in Scotland of domestic abuse, but is recognising that when we talk about domestic abuse, there are other people impacted by that domestic abuse as well, who might not be covered by that definition as it applies in the civil and criminal courts, because there are very important protections which need to be applied in those arenas where the definition does need to be very clearly defined.
I'm very grateful. Dr. Boughton, on that exact point, in your submission, you talk about the categories of people who are in section 9.2 that are currently captured. And what you suggest that this committee should be doing is finding out whether it's been discussed at government level. Yeah. You don't go on to say what we should actually do in terms of the definitions. Now's your opportunity. Could you tell me what I should do?
Oh, if only it were that easy. So for context, in England and Wales, in the Domestic Violence, Crime and Victims Act of 2004, which is where the domestic homicide reviews currently sit within that piece of legislation, it widens out the victim-perpetrator relationships that are looked into to also include a member of the same household as himself. So this will include victim-perpetrator relationships that aren't strictly classified as intimate partner or former intimate partner or even familial, but those that share the same living space, where abusive behaviours can also come to fruition. And the reason I just pop that there because I've learnt a lot this morning from listening. So I just put it there for consideration because, like I say, it is looked at in England and Wales, and there are cases available on the Domestic Homicide Review Library that I've linked to in there, whereby these types of cases have been included and have been reviewed. And I think because it obviously is ever so slightly different, but you still have those similar abusive behaviours and tendencies that can become evident in these types of cases where individuals perhaps are living together. If you think of, you know, in Edinburgh, for example, there's a big university community with Edinburgh Napier University and the University of. So what happens if, you know, you have these collective of individuals that come together are in the same living space, and those abusive tendencies perhaps come out within those particular types of relationships. Coercion and control, we know, can manifest in various different ways within relationships, financial abuses, etc. So that was kind of added before listening to the conversations had this morning, and I was just interested as to whether those had also been taken into consideration, because obviously I predominantly come from the English and Welsh background, so was interested as to why that seemed to have been omitted within the bill as it's currently drafted.
I'm very grateful, thank you.
Thank you.
I don't know if any other members have any questions that they want to ask specifically on the sort of definition, which was something that we covered this morning in some detail. If not, I wonder if I can move on more to the actual process. I've got a question just relating to a piece of your written submission, John, and it relates to the possibility of a joint review process, which I was quite interested in. And you correctly referenced that the bill promotes consideration of the possibility of a joint review with mutually agreed terms of reference. And terms of reference was something, I think it was yourself, John, that you set out some thoughts around the the importance of terms of reference, which sometimes, if those are absent, really compromises a review process. So I'd just be interested in hearing a bit more about your thoughts about potentially a joint review process, but maybe pulling in the importance of terms of reference.
Yeah, thank you for that. I think there's a couple of really important considerations. One is always thinking about what's the impact on families, surviving family members, of multiple processes ongoing at the same time, and how can we reduce the demands on them at a time when they're coming to terms with their own grief and the particular horrors around whatever's happened, whether it's a homicide or a suicide. So one is trying to think about how do we, as professionals and as a state, take responsibility for trying to be more trauma-informed about how we engage with families at that time. The other, as we've heard, the other point which we've heard this morning is about the challenges that many services are facing at this moment in time in terms of the demands a need for what they do alongside the resource that they have available. So therefore, helping agencies to bring things together and do one thing well rather than to be asked to do two or more things and then struggle to try and resource them in a way which is appropriate, I think is a very good principle to be following anyway. I've experienced when I lived and worked in Northern Ireland, where I chaired the child death review arrangements. We quite often commissioned reviews with other public bodies, whereby we had legislative responsibilities to undertake a review, but thought that it would be better for those two reasons to conduct a single review. And the key was about both organisations feeling comfortable that their legal responsibilities could be enacted through a single review process, and that the terms of reference became part of the architecture that supported that, and feeling that sort of both mechanisms would get what they needed out of it in order to fulfil their responsibilities. But it went beyond that terms of reference. It also meant that the review panel, or whoever was undertaking the review, had sufficient expertise and knowledge to be able to cover the wider range of issues that then needed to be explored through the review process, and having a way of ensuring that each body felt that that would be sufficiently covered for them to have confidence in whatever the conclusions were that were drawn by the review. So I think it's definitely possible. It happens in other jurisdictions. The key thing is just having a protocol in place that sort of facilitates that from the outset, and that you have organisations and bodies who are committed to working together, as opposed to feeling that in some way doing a joint review diminishes the status of what they're responsible for looking at.
Okay, thank you for that. Grace, do you want to add anything to that? And then I'll maybe bring in Neil if he's got any comments.
Yes, I think this is a really important point for everything that John has said, particularly when you're looking at the reviews being conducted on the ground, as it were. So the amount of people that are taking up with these reviews, who are often, criminal justice agency members, staff members who are doing it in addition as well to their day jobs, which is also something to consider. In England, we can also have joint or parallel reviews, albeit I think joint reviews now are the preferred vehicle. However, there's been some diversification of process over in Wales of late. So the Welsh Government now have the single unified safeguarding review process. So this was a piece of work undertaken by Leanne James and colleagues from a Welsh Government perspective, but also underpinned academically through work by Professor Amanda Robinson at Cardiff University, whose paper was published in 2018, where they were looking at these similar types of review processes that happen across the criminal justice sector. And Amanda's paper concluded basically with the idea of streamlining review processes. So obviously this pertains to England and Wales processes. So those of concern were child practice reviews, adult safeguarding reviews, mental health homicides in particular. And what the Welsh Government have launched as of late last year, they've now gone live with this single unified safeguarding review process. So you have 5 different types of reviews, as mentioned, including now the offensive weapon homicide reviews, which are relatively new as well. And the idea is funneling these review processes into one overarching process. So they all kind of followed the similar kind of trajectory. And again, as John mentioned, that was the idea of being very victim-centred, victim-driven. So making sure that you're not re-traumatising family members, being asked the same things by sometimes, more often than not, the same professionals, but for different purposes. But also, one of the findings from my doctoral research was that the timeliness of the reviews actually taking place takes a very long time. And also with the timeliness of the lessons learned and the recommendations we were talking about earlier. So, identifying them quickly and putting them into practice as quickly and as appropriately as possible. But I'm sure colleagues at the Welsh Government would be more than happy to help and to correspond with yourselves.
Yes, thank you. That might be something worth following up by the committee. I'll bring in Neil, just if there's any particular points you want to add at all. The original question was with regard to the possibility of joint reviews and perhaps the benefits of that process, as John and Grace have already outlined. If you've got any additional points you want to make around that, Neil.
I think that keeping the terms of reference clear if you're blending things is very important. We have probably half the child maltreatment deaths in the United States, very crudely, but probably half are preceded by adult intimate terrorism or coercive control. So there's clearly a need, there's an overlap. So to get those terms correct is is, I think, important, and you could make that argument with a number of other review types as well. I want to follow up on a couple of points that John and Grace made. I think there's a little bit of a danger if we don't have adequate feedback loops from families and communities and survivors of assuming that we traumatize families. And my concern here is twofold. One is that I think we need to have families speak about how they're traumatized and what these reviews might mean to them. Even if there are multiple parallel, overlapping, blended reviews, I think we need to have the input of families. It's very important. The second thing is related, but Grace had talked about setting up a repository and a library of cases, which for researchers is very, very valuable. But at the moment in the UK, because that interface is publicly available, members of the public, anyone in fact, can go in and read the minute details of family members' lives, medical issues, mental health diagnoses, medication patterns. And I think that that is potentially extremely invasive. And if we're concerned about family traumatization, then we ought to be concerned about those things. In the United States, there's no way you could drill down on that level of detail about families' lives. So I would just caution on the repository. So if you do that, then you need a screen there to make sure that, yes, the researchers have access. Maybe. This may be very helpful, and I agree. But for anyone willy-nilly to go in, the media included, to be able to just jump in and look at these fine details, I think is troubling, and I would like to take family guidance on that before you went down that path. Thank you.
Okay, thank you very much. I think maybe Rona Mackay, did you want to come in just to follow up with regard to definition?
No, actually, I think I'm okay with that. I think we've explored that. It was really to ask Neil if he could pinpoint any key areas. The Scottish Government are proposed to be giving guidance for the review bodies and how to carry out their functions, etc. Are there any key points you think should be included in that?
I think an overall brief statement on philosophy and where this came from. I mean, these reviews arose out of successful aviation crash reviews and the desire to have transparency and candor without blaming and shaming. And these, in some ways, are a form of deliberative democracy. And I think keeping that point in mind is really valuable, because if you look at the improvements in aviation, you know, the decline, the declining crashes per mile flown, it is dramatic over the last 50 years in the democracies that do this. And the National Transportation Safety Board was our linchpin for doing this work in a way that was non-partisan politically and objective and scientific. And if you compare that with the reviews in medicine, if you compare that with reviews in, say, the nuclear power field, they haven't been as candid, and we've had other tragedies. So I think keeping that broad philosophy in mind might be helpful.
Yes, I understand that. So what you're saying is that there should be possibly more evidence-based emphasis put on it, and just how it should be more targeted, perhaps. The advice that the Scottish Government give to the review bodies to sort of get the ethos of that over.
Yes, Rona, I think that the idea here for the review bodies is to tap the massive talent available at those tables, those review tables. And that's what they did in aviation crash review. They brought in, for example, pilots, co-pilots, people who sold tickets, people who served drinks. I mean, multiple perspectives. And the multiple perspectives make the difference. And sometimes there are respectful disagreements between professionals. Those disagreements or differing interpretations are really critical for moving these debates forward. These are complicated cases. So that's one of the reasons why I favour having maybe a sample, a practical recognition that to review a lot of suicides is obviously going to be definitionally challenging. But to have 1 or 2 cases in a 5-year period where you select some cases like that, or where you select a case where a son kills a mother, and as John says, these are very important cases, because often those cases where sons kill parents, there are long histories of emotional abuse and intimate terrorism tactics within that household that we need to flesh out. So, I mean, I think that's what I'm trying to say, Rona. If I'm not being particularly specific here, but
no,
yes.
Thank you. That's really helpful. Thank you. Thanks.
Okay, thank you. I wondered if I can come back to process and the proposals around the sort of distinct committee, so the oversight committee and the case review panels. And I think that was something that you were looking for a wee bit of clarity on in your submission, Grace. So obviously they have fairly distinct roles. One is basically oversight and the other is doing the hard work, as it were. So I'm just interested, maybe I'll come to John and then Neil, in your views on is that the right proposal for what we're seeking to do in the bill?
I think one of the things that I've certainly learned from looking at different types of review models, not just around domestic abuse, but also around child maltreatment internationally, has been that there are different approaches. But one of the key things has been that where you have a model where you're reviewing an individual death and that you have a bespoke group of people who are carrying out that review, that actually the quality can be quite variable in terms of what is the end product. We definitely see that in England. Yeah. We've seen that in other places as well. So there needs to be some sort of way of standardising how reviews are undertaken, and picking up on Rona's point earlier on about what is the support and preparation that individuals who are involved in reviewing that individual case get, whether it's the person who's reviewing the panel, who will build up expertise over the time, but also people who may be representing the police or social work or health, about how you help them to tune in to what the task is and to feel supported in doing that. But also what can be produced as a report can be very variable. And the oversight committee that operates in England that looks at their reports, they have a very big task in terms of trying to make sure that some reports are of the standards that are required, that firstly they meet the terms of reference that have been set, that it's clear that the recommendations and learning actually relate to the facts of the case and what has happened, and that actually it's forward thinking as opposed to just looking backwards and trying to give an account of what happened and didn't happen. It's actually analytical in some way. So I think the Oversight Committee have a really important function there at sort of setting out some of the framework in which individual reviews will be taken out, but also ensuring that individual review panels have the right people around the table, that those people are supported to do the job that they're being tasked to do, and that there's a way of quality assuring what they produce at the end. And as Grace has mentioned earlier on, the Oversight Committee then can start to take these individual reports and the learning from an individual case and say, well, actually, there's some themes starting to emerge. And actually, are these not about just recommendations for a local area? There might be something nationally that we should be paying more attention to. And how do we aggregate up that learning in a way which actually informs further iterations of Equally Safe?
Just on that point then, if I ask about data, so if we're learning lessons for the future, I mean, data's kind of quite important in that regard. Is there anything that maybe I'm interested in what comments you might have about how we integrate the collection of data into the review process so that that can inform future policy and direction?
I think that's one of the things that the Oversight Committee can do, is to try and think, is there common data that we'd want to collect around all of these deaths? and not just the ones that end up being reviewed, but the ones that sort of were considered as well. And also, is there a common way of reporting? So that what we've seen in some jurisdictions is that it's left very much to the person who's chairing the panel to determine what the final report will look like. And that makes it more difficult then to, as Neil and Grace have mentioned, to look across reviews to say, well, how do we identify the commonalities as well as sometimes the differences, because the differences may be equally as important as the commonalities. And then how does a body like the Oversight Committee pull all of that together on a periodic but regular enough basis to be able to share that learning with a wider audience and to think, as Neil has said, about who are the audiences. Is it about victims' families? Is it about professionals? Is it about the wider public? And to think about how that information is communicated in a way which is appropriate to that audience and actually is useful and helpful rather than just it being voyeuristic in some way.
Thank you. Thank you. I'll bring in Neil if you've got any views on the more the sort of structure of the process with the Oversight Committee and panel proposals, and then I'll maybe come back to Grace. If not, that's fine.
Yeah, I think John's points are well taken about standardisation. I think obviously having standards, having ethical standards and guidance and quality assurance is really important. I would caution against having quality assurance that rises to the level of something like ideological scrutiny, or something that forces certain interpretations or models on the data. I think that is dangerous. I've certainly seen a little bit of that in some of the homicide reviews in England. I would hate to see standardization rule out the opportunities for innovation. I've been in too many reviews where something new and different has been introduced. I can't mention where, but I was facilitating a review in one state where the team brought in a defense attorney who reshaped the entire interpretation of the case. And it came as an unexpected development when we brought in community members to testify and to give evidence in a rather ad hoc manner, but it was incredibly valuable in terms of stretching the interpretation and what we learned from that case. So standardization, yes. Quality assurance, yes. Ideology, less desirable, but we ought not rule out the possibility of innovation. And then finally, I think we have to ask, how do we dialogue with families and community members after the review? How do we understand the catharsis that families might feel or may not feel about the review process? In other words, those are quality assurances that we need to loop in. Thanks.
Okay, thank you. Any final points on that, Grace?
No, just to say that I think what the Review Oversight Committee will benefit from in Scotland in comparison to the Home Office Quality Assurance Panel back in England is that, according to the statistics provided in the policy memorandum, you have a lot smaller, the homicides you will be considering or that will be going through the process will be a lot smaller. So, currently there are areas are experiencing issues with perhaps traffic going through, quote unquote, the quality assurance processes in England. But I think because you're going to have such a smaller number, hopefully that shouldn't be much of an issue. I guess it would just be to consider that for the case review panels, that you're all here as members of your respective areas for Parliament, that that locality isn't lost as well, and that's appropriately reflected, because as has been mentioned, different areas will have different sort of community cohesion and community feel, and for that not to get lost, I think, at the case review panel level, because that's exceptionally important, I think.
Yeah. Okay, thank you for that. I think we'll just be winding up in a moment, so I'm just going to bring Liam Kerr back in just to ask a final question.
Yeah, just very briefly, Professor Devani, you will have heard the concern raised earlier on these panels that there's a risk that it would be the same faces that we always see in Scotland, and therefore either they may not be completely independent or may be seen not to be completely independent. Do you share that concern? And if so, how can that be avoided? And is there any element of legislative change that we can do?
Yeah, it's a really good question in terms of that confidence that we want society to have, that these reviews are going to be done in a way which isn't trying to favour or excuse what might be poor practice or sort of limitations in services. And I think that's why it's helpful to have sort of this separation of functions between an oversight committee and what happens on a local panel, and that actually a report comes forward to the Parliament every 2 years for Parliament to have some sort of overview and scrutiny of the process as well, that it's operating in the way that you intended at the time when you pass the legislation, whatever the legislation finally ends up looking at. I think in terms of picking up on Grace's point, individual case review panels are likely to be more localised in terms of having people who are involved, who are representing local services being on the panel, alongside having some people who are coming from services which are national, like Police Scotland, but also having representation from third sector organisations that advocate around some of these issues, and actually having a panel in a way hopefully creates the opportunity for challenge within it, but done in a way which is respectful and also is about trying to analyse what's going on as opposed to trying to hold another agency to account. I think the Oversight Committee becomes important then in terms of feeling as though there are some elements of independence, and if what's proposed in the bill about the chairs for individual reviews will be publicly appointed, and that the Oversight Committee, the chair and deputy chair, are appointed, hopefully would give greater reassurance that they therefore aren't representing an organisation or having to defend a sector, but are trying to bring that critical and constructive questioning approach to ensure that we maximise the opportunity for these reviews to be learning opportunities. Because if we don't grasp it, I don't think we should be doing them, because they will take up a lot of resource. They will involve people having to step back from their day job to be involved in the review process, and we have to feel that sort of we can balance out the gains that are to be achieved from them, which I believe are there, from the downside, which is the resource that needs to go into them to do them properly.
Dr. Bowson, do you want to add to that, or are you comfortable?
Yeah, it's a really interesting point that you bring up, and something that was quite evident in my doctoral research with regards to how people perceive panel membership. Some people quite liked the familiarity of seeing the same people. Certain organisations will have safeguarding leads or public protection leads, and would therefore take on the responsibility of going to these types of reviews. And then you kind of, what would happen is people get naturally a bit more comfortable with one another. And then the question is there, does that then hamper the ability to comfortably challenge an organisation, or does it hinder it? I think and this will all come down to the approach that the review committee would like the shape, the actual methodology of the reviews to take place. But I think it is something that needs to be taken into consideration with regards to, whether it's the same people. I would hazard a guess that, with some organisations, it might be the case that it is the same people going, because they build up that knowledge base, that awareness, they know what to do, they know how to prepare for it. So then it does maybe call that independency into question. But equally, if you have organisations there that are third or voluntary sector who have they have less people to call upon anyway to go to these and attend these reviews on behalf of their agencies, you know, and they can only send so many people. It's going to be a balancing act for sure. But, you know, again, to pick upon Neil's point of innovation, maybe this is the perfect opportunity for Scotland to look at perhaps diversifying from what other people have done, maybe piloting, you know, different ways of the actual methodology of these reviews. So I've suggested in my paper that was submitted. So if you're going to, you know, if the review committee want to go down the panel membership route, why not have like a dual, you know, organisations putting up 2 individuals, 2 senior staff members. There was some evidence I found in my doctoral research that junior personnel were going forward for these types of roles when perhaps they shouldn't, because they were struggling with, you know, authority and hierarchy within certain organisations. But, you know, they could be paired up with a more senior member of staff, and then they get to be involved, they get their continuous professional development, etc. You're growing that knowledge base and awareness within organisations, but also you've still got that person with authority that can say, yes, we can commit to this, no, we can't commit to that. Okay, we can look at those recommendations, I can pursue that within house, etc. So again, it was just a suggestion, but I think that's why this is quite exciting for Scotland to be looking at doing these reviews now, because now I think you have at your disposal more than ever research-based evidence and practice-based evidence on these reviews that perhaps, you know, partners elsewhere in the UK haven't had. So I think it's an exciting opportunity for Scotland.
It's very interesting. Thank you both.
Okay, thank you. I think that is going to bring us up to time. So thank you very much indeed. That's been a really interesting session. Thank you, Neil, for joining us from Arizona. You can head off to bed now. So before we close, I'm just conscious that it's coming up to 1 o'clock. So can I just again ask that members are happy for us to defer agenda item 2, which was our review of evidence, and we'll pick that up next week. Are we all happy with that proposal? Okay, with that, thank you, and I now close this meeting. Thank you. Thank you.